All right, good morning, everyone. I have 8:30, so we are going to go ahead and start. I'm going to hereby call to order the Escambia County Planning Board rezoning meeting for October 4th. We do have 5 members in their seats, and 2 more are walking in the door. Actually, now we have 6 voting members and our school board representative, so we do have a quorum. You're okay. I'd ask you at this time, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. Good morning, everyone. Staff members, I'd like to ask if we have proof of publication for the meeting.
Yes, sir.
Okay. Does that meet all of the legal requirements?
Yes, sir.
Okay, Chair will entertain a motion to waive the reading of the legal.
So moved.
Motion, do we have a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. You've been provided the rezoning meeting minutes from the previous meeting. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
So moved.
Motion, do we have a second?
Second.
Second, all those in favor say aye.
Aye.
Opposed? Motion carries. Board members, you've been provided the rezoning hearing package for October 4th, 2022 with the staff's findings of fact. The chair will now entertain a motion to accept the rezoning hearing package with findings of facts and the legal advertisements into evidence.
So moved.
Motion, do we have a second?
Second.
Second, all those in favor say aye.
Aye.
Opposed? Motion carries. Looks like we do have our full voting board now at this time. The rezoning hearing package and the findings of facts, as well as the legal advertisement, will be marked and included in the record for all of today's cases. At this time, we'll ask our court reporter, Dave, please swear in the members of the staff that will be testifying.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case will be the truth and the truth and nothing but the truth.
Okay, we'll get Horace when he comes back in and anyone else that's going to be testifying. Okay, board members, you've previously qualified, in this case, Allison, as an expert in the area of land use and planning. Do any of you have any questions regarding her ability to offer expert testimony in that area? All right, hearing none, Chair will recognize her as an expert in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, it's less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form located at the back of the chambers. You will not be allowed to speak unless we have received a completed form. Please also note that only those individuals who are here today and give testimony before the Planning Board will be allowed to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented to the Board of County Commissioners, therefore all testimony and evidence must be presented today. The Planning Board will provide a recommendation for each rezoning request to the BCC. They will then review the testimony, documents, exhibits, consider closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of that decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date that the BCC either approves or rejects the recommended order of the Planning Board. All written or oral communications outside of this hearing with members of the planning board is considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, the chair will ask that any board member have been involved in any ex parte communication, identify themselves and describe that communication. The rezoning criteria is up on the board for your review. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. Approval conditions. The applicant has the burden of presenting competent, substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area as the mailed notifications. A logical and orderly pattern shall demonstrate each of the following conditions. A, consistent with the comprehensive plan. The proposed zoning is consistent with the future land use category as prescribed in LDC Chapter 3 and with all other applicable goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU map amendment, it must be transmitted to the state agency for review. The proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning established provisions prescribed by the proposed district in the chapter. C, compatibility with surroundings. All of the permitted uses for the proposed zoning, not just those that are anticipated by the zoning application, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residential activities that are currently protected by fair housing laws. D, appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences within those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interest between the isolated district and the adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within an area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it's in the public's interest to allow new uses, densities, or intensities in the area throughout that rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to contribute to sprawl. Excuse me. At the beginning of each case, as long as there are no objections from the applicant, the staff will present location and zoning maps as well as photographs of the property. Next, we'll hear from the applicant and any witnesses that they may wish to call. Then we'll hear from the staff, any witnesses they may wish to call. And finally, we will hear from anyone who has completed a speaker request form. So today we have two cases, and we will go ahead and move directly into our first case. The first case is Z 2022-14. Jason Lashley is the agent for Cater Incorporated, the owner, Pine Forest Road, and it's 4.04 plus minus acres from HDMU, which is High Density Mixed Use District, to commercial district. The Dwelling units is compatible at 25 dwelling units per acre on both of them. At this time, I'm going to ask our board members, has there been any ex parte communication between you, the applicant, agents, attorneys, witnesses, fellow planning board members, or anyone from the general public prior to the hearing? Also disclose if you have visited the subject property, and disclose if you are a relative or business associate to any of the parties. And good morning, Mr. Adams.
Yes, a non-voting member, but no to all, except that I have been a customer when it was a Beulah feed store and hardware store. I have been in that building quite a few times in the past.
Okay, thank you, sir.
No to all.
No to all.
Chairman, no to all.
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 All right, thank you. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Okay, and was it properly posted on the subject property?
Yes, sir.
Okay. Mr. Lashley? Oh, yes, sir. Are you okay with them presenting the maps and photography before we get started? Okay, he's indicated he has, so staff, please proceed.
Okay, good morning. Allison Lindsay, urban planner. So this is the location map showing the location on Pine Forest Road. This is the zoning map showing the current HDMU and the surrounding zonings of commercial, HCLI, and MDR and HDMU. This is the future land use map showing the current future land use as commercial. This is the existing land use map. This is the aerial and the wetlands map of the parcels. This is the public hearing sign located on the northernmost parcel on Pine Forest. And this is looking at the subject parcel from Pine Forest Road. This is looking north from the northernmost parcel along Pine Forest Road. Looking north, looking south along Pine Forest Road. And this is the other sign on the southernmost parcel on Pine Forest Road. This is looking across Pine Forest Road from the subject property. This is another looking across the Pine Forest Road from the southernmost parcel, so you're kind of looking northeast. Looking onto the southernmost parcel from Pine Forest Road. And that's the maps and photography.
Okay. Board members, any?
Mr. Chair,
Yes, sir.
I was just gonna say, I did make a mistake. I thought we were on the 9 Mile one first. That
Oh,
was 9 Mile
okay.
Road with the Beulah feed and
Okay.
hardware, so my apologies.
All right, thank you, sir. Any question on the maps or photography? All right. Mr. Lashley, if you'll come forward, please, sir. And we'll have you sworn in and then state your name and address for the record, please.
Or from just what about the case
Morning, sir. Your name and address, please.
Jason Lee Lashley. I work with Sigma Consulting Group, and the address is 3298 Summit Boulevard, Suite 32, Pensacola, Florida.
Okay.
Office.
And board members, I believe that this case may qualify for what we consider to be expedited approval. Allison, so your testimony that the findings show it's compatible in all the categories?
Yes, sir, from the comprehensive plan all the way to the surrounding uses. And it's not spot zoning, so it is an appropriate place for the commercial zoning. It's one lot away from the intersection of Blue Angel and Pine Forest, which is all commercial. So it does meet all the criteria.
Okay.
Let me say something.
Yes, sir.
Yes, I didn't sworn in first.
Okay.
Raise your right hand. Do you solemnly affirm that the testimony about to give in this case will be the truth, whole truth? I do affirm. Yes, as you can see from the sorrows in and out, but this one basically almost like one step up. The maps, even the map shows just, you got commercial all around it. The maps is one step up, so your staff is fully in support of this, as Allison said.
Okay. What we're talking about, Mr. Lashley, is in a case where there's no one here in opposition. I don't have anyone signed up to speak other than you. And the staff's findings support. You can accept the staff's findings as your own because it is in support of the rezoning, and then allow the board to just vote on it without running through all the the details, because it's all part of the record already as well. So is that your wish to move forward that way?
Yes, sir.
Okay. So you'll accept the staff's findings as your own?
Yes.
Okay, all right. Chair will entertain a motion on this, this item, please.
Make a motion to approve case Z 2022-14 based on staff findings.
All right, do we have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries. All right, probably the easiest trip
Yes,
you'll
sir.
ever make to the planning board.
Thank you.
Have a good weekend. All right, we now move on to our next case, which is Z 2022-15. The agent is Buddy Page, agent for Renee Smith, Robert Barnes, and Geraldine Kimenow. I hope I'm pronouncing that correctly. 6300 West 9 Mile Road, and this is from LDR, Low Density Residential, to Commercial District, from 4 dwelling to 25 dwelling units. Members of the board, on this case, I'll ask, has there been any ex parte communication between you, the applicants, agents, attorneys, witnesses, planning board members, or anyone from the general public prior to the hearing? Also, have you visited the subject property, and are you a friend or business associate, relative of any of the parties? Mr. Adams?
Well, now I get it right. So, yes, I know to all except I have been in that building back when it was a hardware and feed store,
Okay.
back in the old days of Beulah.
Thanks, sir.
No to all.
No to all.
Chairman, no to all?
It is less than 2 miles from my house. I pass it daily several times, but no to all.
No to all.
No to all.
No to all.
All right, thank you, everyone. Staff, on this case, was notice of the hearing sent to all interested parties?
Yes, sir.
Okay, and was it also properly posted on the subject property?
Yes, sir.
Okay, Mr. Page, any objections to the maps or photography? He's indicated no, so we'll have the maps and photography, please.
Okay, this is the Z 2022-15. This is a location map showing its location on 9 Mile Road. This is the 500-foot radius map showing the current of low-density residential. This is the future land use showing the parcels are commercial and the surrounding is mixed-use suburban. This is the existing land use map. This is the aerial photograph of the site. This is the public hearing sign that was posted on the smaller portion of the two. This is a view of the smaller portion, I guess it would be on the east side of the two parcels. This is looking north at one of the parcels. This is the public hearing sign that's on the larger parcel next to the Beulah Fire Station. This is looking north into the subject property. Looking southeast along 9 Mile Road. And this is looking southwest along 9 Mile. Looking south across 9 Mile from the subject properties. And this is, I can't read that. This is the corner of 9 Mile Road and Beulah. Sorry, I think I was just showing the intersection, which was about a quarter mile from the subject property. And I believe that's all the maps and photography.
And Allison, on that corner that you just showed, catty corner to that is where the public shopping center is, and
Yes, sir, on the other side of Beulah, and then on the other side of 9 Mile, there's another convenience store and then a car lot.
okay, okay. Yep, I know it, okay. All right, Mr. Page? You've been here enough times to know the drill, sir, so we'll have you sworn in and state your name and address for the record.
I do.
Good morning. State your name and address for the record, please.
Mr. Chairman, Buddy Page, 5337 Hamilton Lane, Pace, Florida.
Mr. Page, have you received a copy of the staff's findings of facts and a hearing package?
Yes, sir, I received both of them, the old one and the new one.
Okay. Do you understand that you have the burden of providing substantial competent evidence that this proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with any portion of the Land Development Code.
I do.
Thank you, sir. Please proceed.
Mr. Chairman, a procedural question first, if I might be able to direct a question to the attorney present this morning.
Okay, yes, sir.
Good morning. My understanding is that the county land development code and other rules and regulations require the county to produce and send to the applicant the findings of fact 10 days prior to the meeting. Is that your understanding?
Off the top of my head, I don't know the exact date or the exact time range, but I can look that up.
Well, generally it is. It's been that way for, 15, 20 years. My question this morning, Mr. Chairman, is that I did receive a copy of that online on September the 28th, well within that period of time. That particular staff finding, all 5 of the items that were required to produce competent and substantial evidence to see if we comply or we do not comply, that particular finding of fact that the county sent out said we did. You know, we thought, great. I notified the buyer, notified the bank, notified the realtor, and notified the owner who's present here this morning that we have a copy of the staff findings of fact from the staff. We got it within the required period of time, and it says that we pass everything. I said it might be a short meeting, given those circumstances. Yesterday, one day ahead of this meeting, I get a brand new findings of fact from the staff. These brand new findings of fact of staff say you don't. You have some problems in 3 of these areas you don't pass. My question to the board this morning, Mr. Chairman, is did anyone receive the original green flag, so to speak, findings of fact, or did you only receive the one that says that we didn't pass muster? That's a general question.
Board, if I can answer that, I actually emailed the board and all applicants and citizens on September 27th, the week before the meeting. And then I also emailed the board when I got the updated staff findings, letting them know that this particular case had changes.
So it was done twice.
Yes.
So, Mr. Chairman, the problem that we have here this morning is that we have a brand-new set of findings that did not follow the statute or the county rules and regulations. And we would ask at the start of the meeting that the county find that the ones that were mailed out, received yesterday by me, and I understand by you, to not meet the requirements that are set out in the rules and regulations of the county. And for that reason, they will not be considered here this morning. That's my first request this morning, Mr. Chairman.
Okay. Going to go to our legal counsel for.
Mr. Page, do you have an LDC citation? Because I cannot locate.
Could you speak up?
Do you have a cite to the LDC? Because I cannot locate a 10-day requirement.
I don't have it here in front of me.
I cannot locate a 10-day requirement. Of course, I'm doing quick research. But there are 2 possibilities, Mr. Chairman. To the extent that Mr. Page may be arguing a due process issue, I mean, he's had notice and he has the opportunity to show up today. So either one, he could cross-examine the county's witnesses to get to the root of why there was a change in the findings, or alternatively, he could ask that this rezoning be rescheduled so that he and his client have further time to digest the findings.
Okay.
And if I may, Horace Jones, Director, this has happened before on several occasions. Also, too, we gotta understand this, that the board, I know he said he did some things, but it's clearly written in South Carolina Development Code that when it comes to the board can always, which the board overturned a planning board decision a couple of weeks ago. So regardless of, we respectfully understand that they may have made some provide some risk. But just like on a couple of weeks ago, the board did overturn a decision that was made by this planning board and vote not to approve the rezoning. So the board do have that option to do that. So they're proceeding at their own risk if they decide to do further investments on there. And also too, respectfully, yes, the facts will change, because sometimes I like to get to them as quickly as I possibly can, and sometimes I cannot get to them as quickly as I possibly can. But staff will easily, if you want, that's the recommendation that was given by the attorney, you want to table this, we could get back with the client, and if there's any type of fees or anything that need to be paid, I can make those adjustments, because when I read the facts of findings, I could not say that it met the criteria, based upon my review of the Land Development Code, that it met the criteria of those issues. So therefore, yes, that was mine, but the planning board always had the option to say harsh, yes, it did, but looking at the black and white language of the Land Development Code, and understand that what we have been doing with the last, in the same, similar facts, similar circumstances, that staff could not support the findings that was went out. If we want to table it, we can talk about it. I'll be glad to do what I need to do to discuss with them and pay for it, re-advertisement, if that is the case.
Mr. Chairman, under LDC 2-7.2, which is the rezoning provision, the 10-day requirement has to do with the legal notice, the publication in the newspaper. So I believe that is what Mr. Page is referring to with 10 days.
Okay. We typically, as Rachel testified, we typically get it about a week ahead of time, is what I see, is about 7 days ahead of time, which is when the first version was delivered. Mr. Page, how would you like to proceed as the applicant? Would you ask for a continuance? Would you like for the case to be heard today? It's your call as far as how you'd like to proceed.
Mr. Chairman, we would like for it to be heard today. There is a lot of financial considerations with the bank involved with this as of today. A decision would need to be made by the board, however that might be, today.
Okay, and just to be fair, as Horace said, of course, the Board of County Commissioners can overturn anything that the planning board recommends anyway. So, you would have to be reliant upon their final decision for anything major. But before we move forward, any questions or concerns from board members before we let Mr. Page start presenting evidence?
At the very least, I want to acknowledge the fact that Mr. Page is concerned that, the staff's findings do carry a great deal of weight. I know that also Mr. Page and the applicant have invested, if not, just under $3,000 to get to this point, and waited several months to get to this point. It's unfortunate that they got findings that were completely contrary, and obviously I would be upset if it were me a day or so before as well. I am very interested to hear about some of the past, and I think in this particular case, this is where our FLU, future land uses versus the weight of that I think in the past has been pretty much discounted by the letter of the law and what the maps say right next to it. Because back in the past, somebody invested quite a bit of time, energy, and effort for this the future land use to be part of this, and it meant something at the time. And it seems to me that it meant a lot more than it appears to today in the way we hear these cases. So I'm very interested, and I'm apologize that occurred, Mr. Page, because I think that we forget sometimes. And Horace, no offense, but you and the staff, you guys carry a lot of weight. Not only your opinion on paper, but when you come up, you have the ability to sway both back and forth, not just with us, but other people. And today I was assuming there would be more of a crowd of people, and I'm glad that there's not, quite frankly. I mean, not that I against that, it just appears in looking at the nature of that property, this is where the black and white letter of the law versus, you know,
Common sense.
it seems to make sense, but I'll defer, that's just wanted to say that.
Good. Anyone else wants to chime in before we go?
Mr. Chairman, if you don't mind.
Mr. Wood?
Horse, in the original, I guess, findings that came out, what were the conclusions on those? I mean, I guess what I'm trying to figure out is how do we go from, as Mr. Page is stating, a full green light, if you will, to 5 days later, we've got some roadblocks in the way as far as what staff is finding. I mean, I guess I'm a little confused on where the miscommunication might be and.
Yes, and I do understand that, and I take full weight of that. I do understand that. Again, I have to look at, the final decision is always mine. And I have to make sure that the code is followed to the best of my ability. I just can't look at what's on the ground per se. I gotta look at the total area. And looking at those facts or findings that were previously done, it was my decision that they was not as clear, they was not as in agreement with the black and white language of the Land Development Code. Yes, and we can discuss that further, Mr. Powell, about the inconsistencies. We can talk about that. But to address your, that's why, Mr. Wilson, because if we have to be very, very careful, especially when it comes to rezonings. And I'm always more critical. I am more sensitive when it goes from LDR all the way up to a commercial zoning. I always take a much more logical, much more thorough review when I'm looking at that. And my phone is ringing again, like it always does. I'm so embarrassed again.
All good.
You know, they do have mute buttons.
But that's, I mean, seriously, we have to be more critical because we do not want to start a proliferation of strip commercial zoning down Beulah Road, especially in that rural segment. Yes, part of Beulah Road is definitely going that route. But when I looked at it, I said, wait a minute, do we want to create and start some sins of the past, Mr. Powell? Do you want to start that with that proliferation of strip zoning going all the way down, especially in the large vicinity of LDR, especially in the lower impact of that rural community section of it? We can, so that's why I said, let me look at it more critically, and more thoroughly, and more holistically in lieu of the Land Development Code. So I hope I answered your question.
Mr. Jones, I think you might have misspoken. This is 9 Mile Road.
9 Mile
You said Beulah Road.
Yes,
I just
yes.
want to be clear that
Yes,
this
yes.
is not West 9 Mile Road,
Yes.
so. Okay.
Yeah, Mr. Chair.
Yes, sir.
I just want, Horace, I see this is 25 residential dwellings per
Yes.
acre.
Yes.
Has there been any feedback to Mr. Dennis in Operation School District? That sits in Kingsville, which is that capacity. So I just want to make sure, has there been any discussions with school district?
No, it has not at this point because nothing has been submitted for anything to do. Not at this point, but that will be considered. And as you, as a representative, you can always state your point of view
Okay.
on that. Yes,
Okay.
sir.
Okay. Any other questions before we get into testimony? All right, Mr. Page, just a reminder, obviously the updated findings show that it's not compliant in several categories, so it will be your burden to convince the board that you are compliant in those categories. And board members, when making a motion, obviously you'll have to address that your finding for your motion is different than the staff's official findings of fact when making that motion. So, all right, Mr. Page, please proceed.
Thank you, Mr. Chairman. Mr. Chairman, the history of this site and the way it's been handled is of great importance, and I'd like to make several things part of the record. Let me first ask if the old findings of fact, I need to submit all of those for the record in the event the owner chooses to take some action down the road. So, Mr. Chairman, I have a copy of those old findings. I'd like to have these entered into the record.
All right, Mr. Page, are those copies true and accurate copies of what was produced by the staff and distributed to the public?
Yes.
Okay,
It was taken from the county webpage.
Okay, and you personally printed all of these out?
I did.
Okay, if you'll give them to the attorney,
Yes.
and if he has no objection, Chair will entertain a motion to accept into evidence.
So moved.
Motion, second, any discussion? All those in favor say aye. Aye, opposed? Motion carries. Let's label those as Exhibit 1 for the applicant Exhibit 1.
And Mr. Chairman, it should be very clear in the record that the applicant's exhibits are not the county's official findings as it pertains to the rezoning.
Right, so it would be considered that he would be presenting those as his findings in this case, even though they were written previously by a staff member, he's adopting them as his proposed findings. Is that correct?
I don't want to speak for Mr. Page. Is that correct? Then yes, Mr. Chairman, based on Mr. Page's assertion, these would be the applicant's findings of fact.
Okay, so we'll label them as applicant's Exhibit 1, applicant's findings of facts. All right, go ahead, sir. Okay, we have to introduce them into evidence. Tell us what those pictures are.
Mr. Chairman, what's being passed out now, just to give the board some feel for what used to be on that site, even though it's completely vacant now. These are pictures provided by the owner of the property that dates are right at 1972. I think a relative of the owner has a 72 Corvette in one of the middle pictures that you have there. Are those distributed yet?
Oh, okay, hold on just a moment. Mr. Stroud, as a matter of bringing them in as evidence, since he did not take the pictures, how would he introduce them as evidence into the?
Do you have the photographer present here today?
The owner sits right here, that photographer.
It would be best for the person who
That's what I'm
took the photos to explain what they are, that they in fact took those, and that they have not been altered or amended in any way since they were taken.
Okay, so let's go ahead and bring up.
If you allow her a few moments.
Mrs. Kiminell? No, I'm Renee Smith. Oh, Smith, okay, I'm sorry. Okay, if you'll be sworn in, please, by our court reporter.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give in this case, be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, if you'll state your name and address for the record, please.
Renee Smith, 6030 West 9 Mile Road, Pensacola.
All right, good morning. Mr. Page, your agent has submitted some photographs, and if you would just please explain to us what they are of, and if you personally took those pictures, approximate time frame of when you took them, and just explain to the board what they are, please.
The first one is,
Would you pull your microphone towards you just a little?
there we go.
Thank you.
Better?
Yes.
Okay. The first one is actually looking east from the side property. That's when we owned the store. It was a Union 76 gas station when we first bought it.
Approximately what year was this?
We purchased it in 1972.
Okay, all right.
And, but this one shows the side view with the old phone booth. And then the middle one is the one that he was referring to that shows the Corvette of my mom's. That's the front section of it where the gas pumps were. And off to the side, we had a garage where my brother did work on it. But that was, and then the third one is the inside, a copy of the inside of the store. It was a grocery store, gas station, feed store. We kind of did everything there.
Okay. All right. Board members, she has testified that these pictures were taken personally by herself and described what they are. Chair will entertain a motion to accept into evidence.
So moved.
Second.
Motion and a second. All those in favor say aye. Aye. Opposed? Motion carries. We'll label them all as one exhibit. Exhibit B for the applicant, the pictures.
Mr. Chairman, is it B or 2?
I'm sorry, 2. Thank you for correcting that, Dave. Okay, go ahead, Mr. Page. Mr. Page, you may proceed.
Mr. Chairman, this is submitted just to show that there is a history of commercial activity in this particular area that dates back, they bought it in '72. It probably was in sometime in the early '60s that this particular commercial activity started out on 9 Mile Road. So the history of it is fairly evident in these pictures and the testimony that you will hear. And all of this is only to point out the fact that this is a large piece of commercial activity going on that most anyone driving down the highway in the early '70s, late '60s would see that it is a service station and it is a neighborhood convenience store. However, the Growth Management Act of Florida 1985 required counties to have zoning and have a land development code with a future land use map. Escambia County, and I was present way back then, the only zoning we had in the county back then was the 1 mile radius around the University of West Florida. City and the county got together and decided that they would approach this and zone the whole county, but a number of items had to be done first. One was a windshield survey. In order to put a map down, you have to know what's there in order to identify what a future land use map might be. Those windshield surveys were conducted. The county had 3 different activity periods that was done. 9 Mile Road South was 1, 9 Mile Road to Atmore Cutoff was 2, and then north of that was Walnut Hill. A lot of public hearings, a lot of presentations made, a lot of decisions made. But the problem with all of that is that the map that was shown at those meetings did not pick up this particular land use out on 9 Mile Road, nor did it pick up the Bridlewood and 9 Mile Road convenience store service station, which is about 900 feet to the west of this site. Neither of those got picked up. The consequences of that is if you didn't get picked up on that early map to show that you were a commercial use then, when you look at the future land use map, you're looking at low density residential, or back then rural residential, so they were missed on the first round. They were not picked up. An opportunity to pick that up again occurred in the probably the late 1990s or early 2000, when the county revised a lot of maps, a lot of plans and what have you. Another confirmation survey was done, and these 2 sites, and we're only concerned with one here today, but both of these were missed again. So there were 2 opportunities to get it right in terms of including these particular uses as legitimate and part of the county record. They just were overlooked. In 1987 and 88, the county held a number of public hearings. The owner of the property, Ms. Barnes, attended those public hearings. She thought she was attending a commercial zoning type of public hearing. And when all of this came up, and the realtor got ready to sell the property here 6 or 8 months ago, he found out that the paperwork she had really did not show documentation signed by Buck Lee back in the day, that her property was commercial on the zoning map. All of those hearings were for activities to be classified on the future land use map. So they got another opportunity to get it right, and they did on the future land use map. The problem with all of this is, had they originally been picked up on the two surveys that the county had, they would have been identified, yes, that's a commercial use, been there a long time, clearly evident, no one could miss it. Well, that's strike two. So then today, we have another problem that's been presented in that the county has changed their findings. Mrs. Barnes is very upset and concerned about how 3 times in a row she's had an opportunity for checking on the staff findings, the staff activities, the staff windshield surveys, and they were never picked up. No fault of hers, certainly no fault of any staff that's here today. It just happened a long time ago, but it happened. So we're trying to straighten that out here today. So, Mr. Chairman, the new findings of staff under the approval conditions, under item number 1, whether it's consistent with the comprehensive plan, staff findings state that it is consistent with that. Item B, consistent with the land development code. This is where the first no appears at the county, that it does not, under the findings on LDC 2-7, compatible with surrounding uses, and the findings on 3-2.10, the commercial district findings. It says, the proposed amendment to the commercial is not consistent with the intent and purpose of the land development code. The applicant is requesting, and it goes on and on and on. Had they been picked up on the map, the low-density residential would have been commercial. We wouldn't have to be asking this today, but that was missed. And it also states under 3-2.10, commercial would be more similar intensity as the conforming commercial developments. However, this is more rural part of 9 Mile Road. Adding more commercial to this area would not be consistent with neighboring residential parcels in the 9 Mile Road area. Compatibility, Mr. Chairman, they talk about things that happen next door. You take a look at the map of this particular site. It is bounded on the south by 9 Mile Road. It's bounded on the east by the Beulah Fire Department, which wraps around and goes to the north. So the fire department is to the north and to the west. And to the east of the site is an existing commercial building that's been there since 1987. So the notion that it's more rural out there than different areas, I don't think stands up once a land survey is done. It's just stated. It's not really backed up with anything more than just that.
Mr. Page, that property to the east, that's a commercial parcel? Is that what you're saying?
That is a commercial parcel. It's not zoned, but you'll see it right here, the little elongated building north and south, that one right there.
What is the nature of the business there?
That used to be a small parts store, or not a hardware, but my understanding is lawnmower parts and that type of thing. And they are fixing that up to have that rezoned for commercial as well. But when he references commercial activities, that's one right next door. That's what I was talking about.
And, okay, thank you. And the next property over to the east again?
That is a vacated church that is for sale, being advertised as a commercial site, which is incorrect.
Okay.
But it's been vacant for 6 or 8 years at least, I would think.
Okay, and the parcel to the west is county-owned?
Yes, you
by
can
the
see the
fire
red fire
department.
department top there.
Okay.
And they're building a brand-new facility and entranceway all along that, and you see that it goes long and slender, and then up in that area, that's all fire department and county, Escambia County property as well. So it's not surrounded by single-family homes. It's not surrounded by low-density residential of any type.
Okay,
Even though what you see up there is low-density residential, that, the uses out on the ground differ from what you see on that map. You can see the purple color for an industrial area. That guy is in the heavy semi-tractor trailer rebuilding business. He takes out the insides of tractor trailers and replaces it with steel. So there's a lot of activity there. It's correctly zoned as industrial. However, the little corner right next at that intersection there is the store that I referenced here a little bit earlier, the Chevron Food Market.
and that's on Bridlewood, on the corner,
Yes,
9 and Bridlewood.
That's correct.
Okay. Is, this may be a question for staff, but why is that not showing as commercial? Is that the convenience store in the corner of Bridlewood and 9 Mile Road?
Corner of Bridlewood and 9 Mile.
North side, northeast side,
Northeast, right to the right. To the right.
go to the right, go down, right there.
Well, they may have had a conditional use by the Board of Adjustment, or they may have been that prior to the zoning and the future land use is mixed use.
It was just missed as well.
So,
Mr. Chairman, my
That one
whole
right there.
reason for mentioning that is that there was an opportunity for a map to be very correct and concise and reflect what's actually on the ground. So they missed us, and they missed this guy down there as well.
Okay.
And he's not a part of anything here today other than just referencing that it is a use and it was missed.
and prior to the LDR, it was rural residential, so some of those commercial type of uses may have been allowed in the rural residential.
Oh, yes, oh, yes. Yes, if I may. Yes.
Say your name again.
Horace Jones again. I mean, when we looking at the history, we really need to pay attention to the facts of the history. Rural residential zoning was a low impact zoning. Low impact zoning for, listen, yes, oh yes. Yes, it was low. I can, it was allowed per the land development code. And many, and listen thing now, listen thing. Many of those uses too, Mr. Powell, we gotta understand this. Many of those uses, if the uses was continuing to be in operation, regardless if they did have the right zoning, they could continue. That's part of the land development code too. But when it go out, the land development code says that it got to comply with the zoning. And when we can go over back with the CCAS studies and all of the split zonings and many of those things, but rural residential, it was a farm-like area zoning where you because you got the farm, you want to have some type of commercial uses, but you still want to respect the farming community for their needs.
How does that, if I can interrupt you, how does that kind of mesh with the fact that when we said we were very careful not to down zone anybody? And that's exactly what we've done here.
No, we did not.
How can you say that commercial usage as LDR or rural residential, as a gas station, have they had to go back and cap off the gas? Have they had to pull those out? I'm just asking, have they been pulled out?
Mr. Powell, I don't know the history of that, so it's hard to me, we're not talking about that. I can't provide no history.
Well, you're
but I will
saying that
be-
the history rural residential was allowed, so, I
Yes.
mean, you can't,
Yes.
and you said the sins of our past.
Yes, sir.
I'm saying
Yes,
it was
sir.
commercial.
Yes, sir. I'm not.
And it
I'm
is
not-
commercial.
I'm not saying that a gas station was not a commercial use. I'm saying this specifically. There are certain zoning categories that would allow for that. Also, too, there are certain uses that could have been in existence prior to the zoning now. So that's what I'm saying. Now, again, there were many issues. We got zoning very late. So I don't want to go through, but I can get history on that gas station if I
But
need
you had,
to.
wait, you had a history with this particular site?
Well, based upon.
And that's why, wait,
Yes, sir.
but why would you bring that up other than, is that why it was changed to LDR?
No, sir, no, sir.
Okay, then
Well, this gas station was built in 1981.
So that's,
Currently, it is a home. It's a single-family residence.
so therefore, Mr. Powell, thank you, Allison. That's why,
The people that own it are saying it's not a single family home.
Okay, hold on, let's come back. Mr. Pyle has the floor, he's asking questions right now. Let's let him finish his questions.
let's pull up and see. I don't know the history of
Again,
that.
again, but you're saying the sins of our past, and now you're saying the history you don't know it. So it can't be both ways. So let's stop this whole line of question. I don't care. It was a gas station, and what you're saying, our disagreement here is that a gas station, while I would say it's commercial use, you're saying that okay, that commercial use could be applied back in rural residential because the people doing their farms needed gas too. They needed, okay, I get that, but I would state that if the law of our mindset when we went in and put in zoning was never to downzone somebody, that people were very careful to do that because then you're removing rights from people, which is evident today. This is why we're here today, because it got missed twice in whatever the survey that they did, or totally missed. But your contention is that it wasn't missed, that it should be LDR or rural residential back then. Is that correct? Like when they did the original survey, back when Mr. Page was saying that, are you saying that it should have been, it was done correctly?
Mr. Powell, this is my response to you respectfully. This is my response to you respectfully. On the zoning, I know the history. On this particular site, it is not fair for you to want me to engage on the specific requirements of that site. I know the site of this rezoning request. So that is I can give you general observation on the zoning. Now you may not like what I'm saying, and that's your choice. I can give you the history.
I'm not arguing.
of the
Here's
CS.
what I'm asking you, Horace. Would you agree with Mr. Page? You either agree or you disagree with him. That back when we did this, when they came through and did the windshield survey, as he stated, that this site was simply omitted? Or is it your contention that it was not omitted, it was properly left out and should be a rural residential or a residential place? That's all I'm asking.
Mr. Powell, this is where I can answer your question on that. It could be both. Without me knowing, I can give you a black and white answer on that question because I was not involved with that particular. Mr. Page was. I was not involved on that particular zoning when the original zoning came in. So I cannot answer that question.
I have a follow-up question to that.
Yes, sir.
So when the change went from rural residential to LDR.
Yes, sir.
You were here at that point.
Yes, I was.
Okay, because I think I was on the board at that time when that happened. And so there was a conscious decision at that point to then omit those more, let's just call them commercial uses in this category from RR. It was permitted in RR, like he said, for farmers to get fuel or whatever. But when it went to LDR, it was no longer permitted.
The LDR is a single-family dwelling use. It does not allow
Only.
It does not allow for commercial operations.
Okay.
Now,
And I think, and you could probably see why he's saying that appears to be a downzoning, because if you were allowed to do something before in RR and now you can't do it, it does seem like you've lost some rights in that process.
that could be a logical assertion, but again, that is not all that has to be researched. One could make that rational opinion if they so desire, but for me to say yes wholeheartedly, I would have to research that matter because I was not involved. Mr. Page was involved with the zoning at the time.
Okay.
When our original zoning, yes, LDR, and LDR, when we did consolidate, we can go over the history. You was here. We had over split zoning properties and so many. So we can just say all RR go to commercial. That would have been, that's not the intent of RR. So, we made it compatible.
And I fully respect you. You've been doing this job a long time, and you obviously know this code better than a lot of us do. To me, I think that the reason for the board being here is in these specific cases where we have these issues is for the board to try to fix these things at that point. That's my opinion,
Yes,
you
sir,
know,
Mr.
is,
Brisket, yes, sir.
so.
Yes, sir, that is the assertion of the board. The board has overturned staff positions before, that you do have that right. The board can make another recommendation. That has happened before, regardless of whatever staff may say. If you feel like that's your responsibility, you answer, well, yes, my opinion do carry weight, but you do have the right to overturn, and that has happened on numerous occasions. So please take that right if you are inclined to do so.
And, Mr. Chairman, I would like to make a correction. I was on the wrong road. It's not, it is a gas station. I apologize. I was looking at my map and I had the wrong location. So,
Okay, all right. So you're changing the testimony to that it is a gas station. Okay, all right, very good. All right, before we let Mr. Page continue, any more discussion on this issue? All right, go ahead, Mr. Page.
Thank you, Mr. Chairman. Bottom line, in fact, to all of this is if it was commercial and it missed out on a windshield survey, it didn't get the benefit of being classified as commercial on the map. And that's what we have a problem with here today that we're trying to correct. So, Mr. Chairman, under criteria C, compatibility with surrounding uses, I think I pointed out to the board earlier that the surrounding uses include the fire department on the west, fire department on the north, and an existing former commercial use building still standing and being renovated on the easterly side. So to say that it's not consistent with the surrounding uses, I think is certainly an error, and we disagree with that. Mr. Chairman, under sprawl, the staff findings are that it could be considered spot zoning. Spot zoning is a very interesting set of facts that have to be present, and we feel like we are not part of any spot zoning in the sense that is the spot that we're sitting on going to be different and cause harm in any way to anything that is around it. I've indicated earlier we have a 4-lane road, 2 sides with a fire department, and a 3rd side that has a commercial building on it. To think that it is a spot zoning for commercial or non-residential use, I think is a far-flung stretch of the imagination. We think that we are consistent with criteria D because it talks about spot zoning is something that's different from zoning on all contiguous land sides. And I've just indicated what land use there is next door to us, so we don't consider that to be a spot zoning. As a matter of fact, I was out there yesterday. I can't imagine a person coming up saying, we would like to buy this property where the convenience store used to be, Barnes Supermarket, and I want to build a $400,000 home. I want to be right next door to the fire department on 2 sides. I want to front out on a 9-mile road, which has increasing traffic on it every day. And that's where I would like to be. I think that's a far-fetched idea that for some reason it needs to be reserved and preserved for some type of residential or rural use with everything that's going on 9-mile road.
Mr. Page,
Yes.
can I make just a statement based on what you just said, which I completely agree with? The fact that there's nobody here that is opposing this, and most of these people lived out there for a while. Okay, we got one person that's opposing it. Okay. I would say that the community kind of agrees that this area has been and will be commercial in the future. So, thank you.
Mr. Chairman, not only that, but the board may,
I'm sorry.
While he's at that point, I've got a question, because you said you don't foresee any way, and I saw these other pieces of the property you're saying that it's for sale too, beside it. There's no consideration to put one of them big apartment duplexes there, right?
there's no
On that
plans for
property?
that, no. As
Okay.
a matter of fact,
Because if we
buyer-
start that in that zone of that Kingsville, I'll have to talk to Commissioner Bagash, because if that And that could be whoever buys the property, but I just want to let you know, there would be a problem if we're setting up a pattern of those big apartment duplexes popping up in that area right there. So that had to be
No
a conversation
guarantee
between us and
on-
the county commissioners.
No guarantee on anything, but I will tell you that the buyer of the property has architectural plans to build a storage warehouse up front and a car wash as you make your way around to the back.
Okay, okay.
He's got a lot of money invested. I can't see that he would turn
Okay.
around and
All right, you know what my concern is.
And
That would
again,
open
I
up
don't
a-
think I would want to rent an apartment where I could look down on the fire department and listen to their fire trucks
Okay,
go out.
all right.
And also, Mr. Adams, the future land use is commercial, so it will not allow residential at this point.
Oh, okay, all right,
Thank you.
feel better.
So, Mr. Chairman, we think that we, for the reasons stated then, that we are consistent with criteria D. And finally then, criteria E, appropriate with change or changing conditions. I think the statement from the staff says it all. The surrounding properties have changed, and that's generally a finding that things haven't changed and maybe your zoning is premature, or things have changed and there's a lot of things going on in that particular area. As a matter of fact, the north end of Bridlewood Drive, there are a little over 600 acres of land straight up by the interstate that is going through the motions now, designing a residential subdivision up that way. Whenever all of those homes are built, their fastest way to 9 Mile Road is straight down Bridlewood, next door to the service station that got omitted on here. So I just mentioned that to mention, or to point out rather, that the area is undergoing a lot of development, going to have impact on schools, I'm sure. But Mr. Chairman, based on that, then we feel like we meet all of the criteria for reasons contained in my testimony here this morning. We ask that you agree with the recommendations made by the applicant, me, and this presentation, and not those found by the staff and their recommendations in your new findings of fact that was just mailed out to me yesterday.
Okay. Any questions for Mr. Page? All right, Mr. Page, we'll give you an opportunity to come back after the staff's presentation. Who's presenting? Allison, you'll be presenting? Okay.
Okay, so this is Z 2022-15 at the 6300 and West 9 Mile Road, future land use commercial, going from low density residential to commercial. So consistency with the comprehensive plan, it is consistent with the intent and the future land use as far as commercial. The current future land use was changed from rural residential flew to commercial, and it was approved by DCA, which is now DEO. And it was adopted by the Board of County Commissioners in 1992, and there is all the backup to show that chain of events in the packet. We recognize the fact that the request is to resolve the inconsistency presented by the current low-density zoning and the commercial future land use. Because at this point, they are in such conflict that right now you can't have commercial and you can't have residential because they both cancel each other out. So in the area, so the approval of this change would allow more intense uses in the area where it's predominantly rural residential in nature than other sections of 9 Mile Road, more so on the east. The parcels will be using the existing roads and infrastructures. And if there is any current development proposed, they will have to go through development review and address stormwater, traffic, access, and all those components of the Land Development Code. So criteria B, consistent with the Land Development Code. The proposed amendment is not consistent with the intent of the Land Development Code. The applicant is requesting commercial zoning designation for 2 adjoining parcels that total 2.68 plus or minus acres. The current zoning for the parcel is low-density residential, which is a single-family residential and doesn't allow any commercial uses. The adjoining parcel to the west and the north is the Beulah Fire Station, and the parcel to the east are established commercial uses or vacant commercial. Parcels to the north are strictly residential. The parcels do meet the locational criteria to a traffic generator. There's a school nearby, there's a fire station, a plant nursery, vacant commercial, and a church. The request for commercial would be similar intensity as the conforming commercial developments. However, this is a more rural part of 9 Mile Road, and adding more commercial to this area would not be consistent with the neighboring residential parcels on either side of 9 Mile Road. Criteria C, compatible with surrounding uses. The proposed amendment is not compatible with the surrounding existing residential uses in the area. The properties are zoned LDR, commercial, and an industrial zone. The existing uses along 9 Mile Road are a mix of residential and commercial. However, within the immediate subject area, there is predominantly residential pattern with limited commercial use. The proposed rezoning would not be consistent with the residential rural area within this section of 9 Mile Road, based upon the fact and set definition of urban sprawl. Criteria D, appropriate spot zoning. It's determined that proposed commercial would be considered spot zoning based on the definition and the map, because if you look at it, there's all low-density residential around it, and there's no current commercial. Appropriate with change or change conditions. The land uses or development conditions within the area surrounding the properties, they have changed. 9 Mile Road is continually changing, and although the development within the area has remained low-density residential, the request to commercial, the potential uses, densities, and intensities allowed by that district would not be compatible with the existing surrounding development patterns. The proposed amendment would create and contribute to urban sprawl. However, there is, within that quarter mile, there is some new commercial developments, the store and the convenience store on 9 Mile Road, 9 Mile and Beulah. So, yes, this parcel was, the previous zoning was rural residential. It had a commercial future land, it had a residential future land use. There's a commercial business on it, so that back in 92, they did request that the board allow them to change that future land use to commercial. And as Mr. Jones stated earlier, however, it happened that whether the staff at that time did not notice the development versus the zoning when the zoning came into play, I think the applicants are trying to correct that. It was a commercial entity at one time, and we all know 9 Mile is growing. Hasn't hit this side of 9 Mile Road, but it is an arterial roadway. So that's the findings for staff.
Okay. Questions of staff on the findings? Mr. Page, you wish to cross-examine or ask any questions?
A comment, Mr. Chairman,
All right, come to the microphone, please.
has to do with spot zoning. It says under LDC Chapter 6, spot zoning is, and it goes into the definition, and it says, applied to an area of land regardless of the size that is different from the zoning of all contiguous land. And it qualifies that by saying spot zoning is not only prohibited, but due to its potentially adverse effect on adjoining zoning. Mr. Chairman, I don't want to beat a dead horse here, but the adjoining zoning and the uses within that zoning category make this not a spot zoning application process. So I heard something I think was a little bit different than that, but the property and the uses around the site This will not be a spot zoning that's different from the categories and uses that are on those 3 pieces of property, 2 of which are owned by the fire department. Thank you.
Okay,
And
thank you.
I'd like to comment on that. If you look at the zoning map currently, not the uses, but the zoning categories are low-density residential. And when it says for spot zoning, it talks about contiguous land. So it says zoning applied to an area of land regardless of its size that's different from the zoning of all contiguous land. So they are asking for commercial, which is different from all the current contiguous land of low-density residential. So in that way, it would be spot zoning, not the use, but the zoning category itself.
Yes, thank you, Allison, with that. And again, that's the black and white language of the code. That's the black and white language of the code, and that's what we have to go by. We go by the black and white language of the code. Also, too, there was some assertions that I think Mr. Powell stated earlier, not to go back into that. Please don't want to go back into that. But I just want to say this, is that it appears that the gas station was built in 1981, and that use is continuing. So therefore, that's what, from the Land Development Code, it is called a legal non-conforming use, and it can continue as is. Now, it also was stated that the gas station was built, that according to the pictures that were shown, 1970, whatever, 2, 3? 72. Yeah, I was in elementary school somewhere. So basically, there was not zoning back then, but now the property is vacant, correct? The property is, I understand the property is vacant, correct, Mr. Bates? I'm sorry? The property, what they want to talk about is vacant.
Yes, the applicant said it's.
Yes, the applicant say that it's vacant. So therefore, the applicable zoning and the rules that we have to go by have to apply now. So, but again, board, I just want to make those, if you have any questions, I'm here to answer. Again, may not agree, that's what the planning board make the decisions for.
Mr. Chair, Horace, I just want to, and this is, what would the proper zoning be for a fire station?
Oh, fire station, now see, I didn't get my code now. Each category, I think fire stations, I think it could become in conditional uses in some of the zoning categories. Give me the code, Allison. It's a public, well, but certain zoning categories still requires, certain type of government use requires conditional use for the boards that will have no impact of the area. So I believe it could require conditional use in those low-density zoning categories. Also, too, it is my understanding, I don't know the history of that fire station, but that fire station has been around there a long time, according to Minor Limited. So if it's been there, again, it's there. So,
Mr. Chair, can I ask one question while she's looking that up?
Yes, sir.
And the attorney made me feel a lot better what he said the use was, but for my knowledge, because I was sitting here looking, I saw commercial, 25 dwellings per acre, and I heard Allison say they could not have resident commercial apartment duplexes is what I was discussing.
let me say what can happen.
Okay.
And this board has made those changes before. An applicant can make, right now, the C zoning category does not allow, with that future land use category, it does not allow for residential uses. However, there is a process for that to be done, and if someone came and made the case in point, and if the planning board agreed to that, that can be changed as well to allow for future land use category to change to mixed use urban or mixed use suburban, which will definitely allow for residential and commercial uses, definitely. And that option is available, and the board have done that as well. So I just want to say that can happen, Mr. Powell. They can, Mr. Adams, I'm sorry, they can make application. Yes, sir.
And the fire stations are allowed in HCLI. I haven't located yet where it can do in conditional use, but it's outright allowed in the heavy commercial light industrial.
So, Mr. Chair, I understand, I mean, look, right off the initial reading of this, I'm thinking, no way can you make a jump from 2. Then you start reading about the history of it. And what I gathered from the history is that the previous, or the owner, really thought they had something when they attended the hearings, and it was a big deal to get categorized as commercial in the future land use. In fact, as I read it, it was almost like they were, exactly what Mr. Page said, they were fighting for zoning for commercial. And that's, I think, what it appears that the owner at the time was, in their mind, fighting for the commercial application to this property when they went to the county at that time, when they were doing the zoning. All the zoning's a little, weird, and this is where we run into it and why we argue back and forth, because it's very similar in my part of the world. I don't want a Dollar General off Gulf Beach Highway within a mile from where I live, but there's one today. It sure is there, and it's right around, and you want to talk about spot zoning, everything around it is residential. Not fire station, nothing even thought of, it's all residential. And I have a hard time though when you have a use that I would obviously argue was commercial, and then we do seem to take away the rights of those people who now wish to do something different with it. I am interested to hear the opposing, I imagine a neighbor, but I don't want to throw rocks at apartments. I used to build apartments, and yeah, you have places that people definitely don't want them, and it's always an uphill battle, but there is a place for them. I don't believe this is it. I do believe, though, that we are, this is a challenge. We're running against the sins of the past, and in my opinion on this isn't based upon what the people did before. It's simply how we transitioned into a planning and zoning, and it's difficult to do that because now all you hear are your friends saying, boy, what's wrong with this county? Why don't they have a good planning and zoning? Because it's a lot easier to throw rocks from the sideline than it is to create this type of thing with any consistency. So here we are, and trying to do this without stripping the rights of the people that own this piece of property and tell them, yeah, you can sell this now as residential, which to me would be I would probably pursue it beyond that. In fact, similar to where there's a Dollar General now, and you saw how that resulted.
And Mr. Powell, and I would like to add, one thing we do, and I'm an advocate for property rights, but also I'm an advocate for properly planned development. I cannot correct many of the sins of the past, and there are many more out there, Mr. Powell. I agree with you. But I just want to move forward so we won't have a proliferation of strip commercial going all the way down. And that is what happened. When you did it for this one, guess what? You're gonna open up Pandora's box. So I'm just trying to provide that for your consideration as well. Urban sprawl is a factor. So and that part of 9 Mile Road, it is much more rural in nature. It's much more rural in nature. Do we want to have a snow sprawl who puts one domino? Here come the rest of them. And then it's going to be hard to put that back in the box. Right now, also to the future land use category, which is C. There are some zoning categories, future land use category, where he can be consistent to still get residential and commercial uses. Perhaps there may be some other zoning categories to consider, but going from low density residential, which that you see yellow all around, we have to take a look at the surrounding properties. We have to. That's part of the thing.
Horace, do you disagree with the future land use categorization of this?
Let me respect.
No, I'm not being smart
no,
aleck. It's a serious question.
Mr. Powell, that is a very good question. That's a very good question. If I was present back then with the knowledge that I do have now, I would have had some hard challenges in saying RR, which is what's RR, rural residential, and going to a commercial future land use category. I believe that I would have made a recommendation for something different than having an RR and a C. And I believe that's why they probably never came back in, because that's been 1992. Perhaps they said, wait a minute, we can't go all the way. We got a future land use category of C. you may can't get that commercial because that's all real residential up there. So perhaps that was their thought process why they didn't come back in to pursue that option. That's from 1992. So again, Mr. President, you asked my honest opinion. With my knowledge that I have now, I probably would have made a different selection, or there would have been more discussions with the applicants at that time.
Can someone advise when this section of the flu was scrutinized?
Mr. Page was present back then.
It was 92. If you look at,
I'm not saying he was the growth battle director back then when we had original zoning.
Mr. Chairman, I'm not sure I got all of that question.
When this section of the flu was scrutinized, what year did it was it established as what it is for the flu?
in the package, remember the hearings when they went to it and they got the designation and they put out each parcel and they designated them as, I think that's the time frame on that was, if I'm not mistaken, 92 or 95.
It was around 1988 for this part of the county. But I will say that if you didn't make it onto that map in 1988, as far as being an existing commercial use on the ground at that time, you missed out on the future land use classification as well. So all of this is what we're trying to correct today.
So what was the mentality of 9 Mile Road west of I-10 in 1988? It was pre-OLF8 transaction, pre-Navy Federal, pre-Publix, pre-Beulah Road widening, pre-everything. It was all...
It was land that certainly was not developed like it is today, but we heard a comment earlier about the domino effect starting. The domino effect has been going on, moving west in this county for the past 10 or 15 years. It's the only area left where there are sizable pieces of land that can be developed. So it has to come along and feed and use an arterial of some type, and that's 9 Mile Road.
Well, I'd like to just say, I'm sorry.
Go ahead.
When I look at this, obviously, there has been commercial uses in that area and is currently some commercial uses in the area. We even have industrial down the road. The area of Beulah obviously has seen tremendous growth in residential. And to me, the best place to have your commercial is obviously along the main arterial roadway. Obviously at the intersection, it's already exploded, but down the roadway. And I just look at, criterion E, if the land uses or development conditions within area surrounding the property of the rezoning have changed, the changes are such a degree and character that it's in the public's interest to allow new uses, densities, or intensities in that area throughout the rezoning. It's obvious that this area is changing. And at one time in 1988, it might have been strictly residential homes along this corridor, but we've seen it. There's multiple commercial uses along this corridor. A Dollar General, a car lot, convenience stores. Obviously, this area was a little pocket of commercial. We have industrial a little further to the west. So I understand Horace is applying the letter of the law the way it's written, but I also think, in my mind, there has been some things done to this property that have taken away some of the rights because of the way that it's been adjusted. I was not aware that rural residential allowed certain commercial uses in it before, and that went away when it went to LDR. I thought that was a more equitable transfer. I didn't realize there was some of those in there. So that plays pretty heavily on my mind. At this point, I'm going to allow the board members who wish to speak, but we do have a public speaker who has been very patient and waiting to speak on the case as well. Allison, go ahead, and then we'll recognize Mr. Sammons.
Okay, so, I did wanna say that, yes, when they did the rewrite in 2015 for the Land Development Code, the people that were doing this rewrite did the best they could, trying not to take any uses or densities away. Now, there were some uses that were overlooked and missed. This one, mobile homes. We did have the savings clause that the county put in place, so if they had a use, say LDR, and they were commercial, and they said, hey, I was able to do this prior to the zoning, so then they could use the savings clause. So that was an option, and it still is an option. And I wanted to get back to the fire station, and it's LDR, but in 2018, they had a conditional use. Conditional use in LDR is allowed for a fire station. So that's how they became to be there.
And if the applicant, thank you, Allison, for that. And if the applicant wants to revert back to RR, that is, we can do that. And we could just modify the code, modify the future land use category easily and do a small scale map amendment. And that's on us. That's on us. That's what the code says, with the savings clause. He can use it, and we can pay for the small scale, and that's what the code says. So if you want to go back to those uses that he had previously for RR, that option is available with the correct future land use change, in which there's provision for that to be done as well.
And also the uses that are there now, if they are a commercial use in the LDR, they're the legal non-conforming, and they can remain until they have closed down or lost they go out of business for the year, and then they lose that non-conforming status, that legal non-conforming status, and then they must either do residential or whatever the zoning is, unless they use the savings clause or rezone.
Mr. Sammons?
Well, I feel a little bit like we're beating a dead horse, and so I'm gonna withhold my comment for a while, but I would love to hear from the opposing viewpoint.
Yes, sir. All right, we're going into that now. For those members of the public who wish to speak on this matter, please note the planning board bases its decisions on the approval conditions and exceptions described in 2-7.2 of the Escambia County Land Development Code. During our deliberations, the planning board does not consider general statements of support or opposition. Accordingly, please limit your testimony to the approval conditions and exceptions described in 2-7.2. Please also note that only those individuals who are here today and give testimony in front of the planning board will be allowed to speak at the subsequent hearing before the BCC. Mr. Larry Smith, sir, if you'll come forward and be sworn in, then state your name and address for the record, please.
Raise your right hand, you solemnly swear or affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, sir. Good morning. Thank you for being patient. There's a lot of technical aspect here.
Yeah.
Please state your name and address for the record.
My name is Larry Smith. I live at 9500 Darling Circle, which is directly behind the fire station.
Okay.
And I've been there since about 1970. I'll be 71 in December of this year. I worked for Gulf Power for 30 years. I did work for the federal government, took 160 Filipinos down to Guantanamo Bay, built a prison camp.
Sir, can you speak down into the microphone just a little bit? A couple of the board members having trouble hearing you.
You may start from the beginning, or?
If you don't mind. Yes, sir.
My name is Larry Smith. I live at My name is Larry Smith. I live at 9500 Darlene Circle, which is directly behind the fire station. Been there since about 1970. That was the year I graduated high school out in San Diego. I come back here to visit my folks and loved the place in Beulah and bought 10 acres right behind the fire station. Since then, the area has really, like y'all know, has really grown. There's a lot of commercial out there already. There's been people that's lived out there that I know since the 40s, and 35 and 40s. And I know the spot where this gas station and store used to be, and it's been vacant for many, many years. My property right behind the fire station, they just bought several acres bordering Rebel Road, and they built about 45 or 50 houses there. And some of them right in a dead-end circle that's right up against my property have two-story buildings, and their bedrooms look out over my property. I can't charge them for scenic view, but that's too close for people moving in on you. And there's one on Bridlewood Road, there's some on Rebel Road, and they're big places. Then you got the Publix out there, and the fire station right in front of me, and the commercial on the northwest corner of Bridlewood and 9 Mile Road, and on the northeast corner of Bridlewood and 9 Mile Road. You got Circle K at Beulah Road and 9 Mile Road. You got Tom Thumb at Beulah Road and 9 Mile Road. You got Publix there. They're fixing to, I saw a sign the other day, they're gonna try and put a car wash right there at Beulah and 9 Mile Road. And there's storage buildings all over the area right now. And from what I heard a while ago, they were thinking about making that land commercial and putting in more storage buildings. We got a storage building 3/10 of a mile from my house, 4/10 of a mile from my house, 4.8 miles from my house, 5.7 miles from my house, 5.7 miles from my house, 5.6 miles from my house, 6.3 miles from my house, 6.7 miles from my house, 7.6 miles from my house, 8.7 and 7.7 miles from my house. That's quite a few story buildings, and I've been driving around looking at them for the last couple of weeks, and most of them are not even half full. That's just too many people, especially if they put a storage building on this property that's they're thinking about doing. That's gonna be right in my back door. I mean, the fire station was there long before I got there. It was all strictly volunteer. I know it's kind of half and half now, but that's gonna be people coming in and out early in the morning, late in the afternoon, all during the night, because it's just key entry or code entry. And it's right there at my property. And a lot of people in Beulah are upset about all the commercials. I heard a while ago too that it was a 4-lane highway, and yet it is not, in front of where this old gas station used to be. It's a 2-lane. And a lot of people, like I said, have lived out there for years and years and years, 30, 40 years. I bought my land from Mr. Donald Hurst, and his family goes back to 25 or 30.
All right, Mr. Smith, I'm gonna ask you to start wrapping up your comments. We do have a timer. You might have heard it go off, but we give everyone an equal amount of time. So if you'll just kind of conclude your comments.
I would wish and pray that the board would leave it like it is, not take it commercial. It's gonna end up like Palafox East. It's gonna be commercial all along the road from there all the way to Scambia River.
All right, I do have one question for you. Your parcel is not contiguous with this one. It connects to the fire department parcels.
Yeah. It's kind of busted up right in there.
Okay.
The houses that they just put in there is only about maybe 40 yards from the corner of my property. And there's, I think, a guy named Steve, used to be the fire department chief there, owns a little section in between me and this land.
Is that on the screen? Is that your parcel?
Yes, sir.
Okay, I just wanted to have in my mind where you're,
Those three parcels right there, that one and the two adjacent to it that are fields.
right, okay, got you, okay,
I bought it and, I built a $500,000 house on it.
okay.
That's what the county says it's worth.
That's for tax purposes.
Yeah, I know, I know, but all these right here. All these right here, the Furrow Lane here. That's where they bought that whole section right there.
Okay, so, we're not picking up your comments because you have to speak into the microphone. But, I heard what you said. You said where Burrow Lane is where the new subdivision is?
Exactly,
Okay,
yeah.
yes, sir.
Yeah, and there's, like I said, I think there was 27 of the new subdivisions built last year.
Yes, sir. There's been tremendous growth in this area.
Unbelievable the amount of traffic on 9 Mile Road, because the 4-lane stops right there at Butyl Middle School.
Yes, sir.
It's done. And there's been more accidents from there out west than there has been. So that's about all I got.
Thank you, sir.
I'd love to see it just stay like it is.
All righty, thank you, sir. Mr. Page, any questions of Mr. Smith? None, okay. All right, anyone else that wishes to speak? Yes, sir.
They did have tanks on that property. I don't know if they've been removed or not, but I've never seen them digging around there, getting them up or something like that.
Okay.
My dad used to have gas stations in Mississippi, and to dig up tanks and remove all the dirt and stuff like it's supposed to be under the tanks, that's quite expensive and quite a job.
Okay, thank you, sir. All right, is there anyone else, there's no one else in the room, but I have to ask this, is there anyone else who wishes to speak on this matter? All right, hearing none, the chair will close the public comment portion of the hearing. Mr. Page? Nothing further? Board members, questions, comments? Staff, do you have anything else to add? Okay.
You know, I want to make sure I understand that Mr. Page, I'm waiting for him to, Mr. Page submitted Exhibit 1 as his intended findings. You presented Exhibit 1 as your intended findings in this case, and they were also the ones that were the findings of the county before Monday or something like that? So, okay.
If that's a question, yes, there were two sets.
Yes.
I believe the timing of it, Mr. Sammons, was about a week before this hearing, the first set went out, which was the one that.
Yeah, the timing's not the issue. I'm
Yes,
just trying
he's
to
using
verify
those
that those are
additional-
his findings.
Yes,
Yes.
he's using the
Okay, he's
original
proposing
one.
these findings. Well, even before discussion, I'm going to move that we accept his findings and approve Z 202215.
All right. We have a motion on the floor. Do we have a second?
Second.
Second, discussion. All those in favor, say aye. Aye. Opposed? All right, motion carries unanimously. Good luck with it, sir.
Thank you, Clerk.
All right, thank you. Thank you, Mr. Sammons. Okay, any action, discussion, info items that we need to talk about? All right, anyone here for public forum? Seeing no one. And Matt, County Attorney report. We know you have some news.
Yes, Mr. Chairman, I know I briefly discussed this before. Just to notify the entire board, I will not be at the next meeting. I have a scheduling conflict with the canvassing board. It's about a week before the general election. So another member of the county attorney's office will be sitting with the board. But the second issue is this is my last meeting sitting with this board. Horace is a little unpleased. Several months ago, I put in my notice, and because I've accepted a position at a private firm in Tallahassee, so I will be working through the general election with the canvassing board and then relocating to Tallahassee next month. but I have sincerely enjoyed my time with this board. And I can certainly say, as a personal note, I sincerely appreciate this board's both competency and professionalism when it comes to dealing with its matters. It certainly makes my life more enjoyable and easier to handle when this board is clearly very well prepared and understands all the issues that come before it. So thank you for that. But someone from our office will be sitting with this board in the future, but I wanted to let you know that this is my last meeting.
Job well done.
Yes, thank you. You've always been very clear and concise and helped us navigate through some of the muddy water that we have to go through sometimes. So we wish you well going into the private sector, and hope you'll stay in touch with the folks here in town. Tallahassee's a great town, but personally, I like Pensacola better, but hey, good luck with
Should
it.
we start getting a complex? Is it something we're doing? Horace, what are we doing wrong here?
We're not doing nothing wrong, Mr. Powell. My department, we give people elevations. I mean, they come and they learn and they get pulled into other endeavors. We really want to thank Matt for his professionalism. I'm saying it publicly. We appreciate him as Development Service Department. It's not easy dealing with land use issues, as this board know. But we thank him. We thank the county attorney's office for always providing us with some of the best to help us navigate through these tedious land use issues. Again, Matt, thank you.
Thank you again, yes. Okay, any announcements or communications by anyone? All right, our next meeting will be November 1st at 8:30 here in these chambers. And please, as always, respond to Rachel and let her know if you'll be here for the quorum. And if nothing else, then we are adjourned. Thank you.